Hello, my name is Sujit Kunan. Welcome to this tutorial on industrial disasters and the environment. In today's tutorial, we are discussing industries and its impacts on people and environment from a legal perspective, that what kind of legal mechanism and legal system we have in India to address the implications of industries on people and environment. So, before we get into that, let us try to understand what is the context in which we are discussing industries and environment, or industrial disasters or accidents and environment. The specific context is the rapid industrialization, and of course, it is needless to say that industries affect people and environment, and in many cases in a drastic way, because the potential of it is needless to explain that the potential of industries to cause damages to people and environment. In this context, probably it is worthwhile to look at the Bhopal gas leak disaster in 1984, and this can be considered as an eye opener in the Indian context when we discuss industrial accidents and its implications on people and environment. And the Bhopal gas leak disaster 1984, it demonstrated apparently in a negative way that what can be the magnitude of such an industrial accidents on people and environment. So, these wider impacts, I mean the implications or the magnitude of the implication is such that it changes or it continues to exist even in different place and different time. For example, even after 30 years, almost 30 years, people and environment in the surrounding areas in Bhopal, they continue to suffer, they continue to face the problems. And many of these problems was apparently difficult to imagine or difficult to predict in 1984 or in the subsequent years when the matter was decided by the court. So, when we look at this issue from a legal perspective, that we need to consider two important issues. One important issue from the legal perspective is how to prevent such industrial accidents. What kind of legal mechanism we have to prevent industrial accidents from happening. And the second important legal issue or issue from a legal perspective is the liability, because we may have several legal mechanisms in place to prevent such industrial accidents, but still the risk continues. So, there is always a risk, and there are chances that the risk can materialize and results into industrial accidents. So, what happens when such things occur? Well, there could be another scenario where industries might have followed almost all relevant rules, or industries' actions could have been perfectly within the legal limits. Still, there could be risk, and there is possibility that the risk materializes and it results into industrial disasters of different magnitudes. So, in such situations, probably the legal answer or the answer from a legal point of view is liability. So, in this module, we will be focusing overwhelmingly on this issue of liability. So, specifically we will be discussing what kind of legal mechanism we have in India to address this issue, how to fix liability, of whose liability, and what is the nature and scope of the liability. Before we get into the liability issues, might as well it's better to spend a little time to understand the liabilities industries in its historical context, because liability of industries in the context of environment is not a new phenomenon, or maybe in the context of environment it is a new phenomenon, but liability of industries per se is not a new phenomenon. For example, industries were, even in the history, even starting from the early 20th century onwards, industries were held legally liable for various actions. However, the problem was that the scope of such liability was quite narrow. Industries were held liable for whatever happens within the premises of the industry, or industries were also held legally liable for all injuries caused to employees. So, what we can say is that the focus of liability was quite narrow, and its scope was limited to the industrial premises as well plus employees working in the industry. So, to put it in a different way, the liability of industry was not extended to the outside environment, but at the same time the incidents like Bhopal gas leak disaster that proved that industries can cause serious implications on environment and people living outside or environment outside the industrial premises. But this narrow focus was apparently the predominant approach in the early 20th century. Say for example, if we look at Workmen's Compensation Act 1923, and this talks about compensation to be given for the liability of the industries to provide compensation to workmen or the employees for injuries caused in the course of employment. Similarly, a similar kind of approach was also adopted under the Factories Act 1948 as well. But however, the key question is, when did this focus expand? Under what circumstance or what circumstances that prompted the legal system to expand the scope of liability? It is needless to explain that the environmental consciousness that provided the important rationale or the context in which the scope of liability was expanded. For example, in the later half of the 20th century, we knew quite a bit about the implications of industries on a wider scale, and probably many industrial disasters such as the Bhopal disaster 1984, oleum gas leak disaster incident in 1985, if we take examples from India, or if we take examples from elsewhere in the world, for example Chernobyl in 1986. All these, in addition to many other oil leakage incidents, oil leak from ships. So many of these incidents that demonstrated clearly the wider impacts of industrial accidents on people and environment outside the industrial premises. Apparently, this prompted the legal system both at the international level as well as in India to respond to this issue. One of the ways in which the legal system responded was by expanding the scope of liability. So, early responses in this regard could be seen in environmental laws. For example, when we look at early environmental laws like Water Act 1974 or the Air Prevention and Control of Pollution Act 1981, and if we look at these laws adopted a different kind of approach as far as industries vis-a-vis environment is concerned. For example, these laws, whether it is Water Act 74 or Air Act 1981, these laws prescribe an administrative mechanism to design some permissible limit for industries. And it also designed an institutional mechanism to monitor that industries are working within the prescribed limit, within the limit prescribed by the law. In many cases, they focused on pollutions and prescribed permissible limits for pollutants, and the industries were expected to work within this limit. So, as long as they work within this limit, there is no question of legal liability arises. But when we look at this, these laws, an important dimension that comes from these laws is like the focus of these laws were mainly on prevention of any kind of industrial accidents or prevention of implications on environment. But the question is, as we already have discussed, there are chances that even after following all these laws or even after working within the parameters prescribed by the law, industrial disaster or accidents can happen. So, what happens when such incidents occur? And probably the answer from a legal point of view is liability. When we discuss liability, we need to also understand from where it originated, under what circumstances this idea of liability was originated. The idea of liability or the concept of liability was originated in the English legal system through a branch of law called tort laws. And there are different kind of liabilities evolved at various point of time. And when we look at liability, it is premised upon this basic principle that no person can cause injury to any other person. If any person causes injury to any other person, that results into legal liability. So, in this case, what we are essentially leading to this concept called fault-based liability. That means, in order to establish liability or in order to determine liability, the liability should be preceded by fault. Fault in this context, in the context of tort law or specifically in the context of negligence, it means breach of a legal duty. When we say breach of a legal duty, it could be It could be a duty to do something, or it could be also a duty to abstain from doing something, whether it is a positive duty or a duty to abstain from doing something. If there is a violation or if there is a breach of legal duty, and then that results into damages or injuries, and this injury or directly or automatically leads to liability to provide remedies. So, this fault based liability has been the dominant rule on liability in the civil law context. But however, I mean, when the time passes, I mean, this fault based liability proved to be inadequate to address many situations, and this is the context in which the English court evolved a new principle on liability, a new form of liability called strict liability. Strict liability was first introduced by a 19th century English court in a case called Rylance versus Fletcher. And in this case, I mean, the court observed, or court introduced this principle of strict liability with the understanding that, I mean, fault liability is inadequate. There could be many situations where where industries or individuals do not commit any mistakes, still their processes or their activity can cause injury or damages to people and property in the neighborhood. So, the idea behind the strict liability was to fix or determine liability even in such cases. This means to fix liability even in the absence of negligence or fault. Or to put it in a different way, the idea behind the strict liability was to cover exceptional circumstances where accidents occur even though or despite the adequate care taken by the concerned person, or in the context of industries by the concerned industries. So, when we talk about liability and environment, we are essentially dealing with impact of industries on people, property and environment. So, first let's try to extend or apply the idea of fault liability in the context of environment. So, one of the problems we face when we apply the fault based liability in the context of environment is, like, I mean, in the case of environmental pollutions or environmental degradation, there could be a number of factors. There could be a number of pollutants or number of actors that cause pollution. Or in many cases, the peculiarity of environmental issues are such that in many cases it is very difficult to realize the long term and short term implications. Many adverse implications appear quite later on in point of time. And in many cases, industries or individuals could be following all relevant rules, and still their activities end up in accidents or disasters. In all these cases, probably the fault based liability is inadequate to address such situations. Or to put it in a different way, there is no good legal reason why victims of such happenings or such industrial accidents should not be remedied. And this is the context in which the idea of strict liability is extremely relevant in the context of industrial accidents and environment. This is particularly relevant in the context of industries that are dealing with hazardous substances, or some industries are inherently dangerous, say for example the case of nuclear power plants. Whatever adequate measures we take, whatever precautions we take, if anything goes wrong, we can easily imagine what kind of implications it can have on the surrounding environment and people. And this is the context in which the idea of strict liability is justified as far as industrial accidents are concerned. In addition to this fault liability and its eventual transformation or the eventual development of strict liability, the Indian contribution to this development of liability principle is absolute liability. This was introduced by the Indian Supreme Court in the Oleum gas leak case 1986. And the absolute liability was particularly, I mean, what we can see from the year the case was considered by the Supreme Court, that is 1986. This is just 2 years after the Bhopal incident. Probably the Bhopal was still in the fresh memory of the judiciary, and that resulted in going to the extreme of enunciating a new principle that in incidents, or in the case of industrial accidents or industries carrying out inherently hazardous activities, there can't be any room for any sort of exceptions that is applicable in the case of fault based or in the case of strict liability. And this was the context in which the Supreme Court introduced this concept of absolute liability. The meaning is that any industries that are dealing with inherently hazardous substances are strictly and absolutely liable. There can't be any exceptions applied in the case. That means there is no way such industries can take excuse in any matter, including their legal compliance. And later on, this absolute liability principle was reiterated by the Supreme Court in the Bichri case in 1996 also. However, what we can see from the evolution or from the transformation of the liability principle in the context of industrial accidents is there is a gradual transformation from fault based liability to absolute liability. While fault based liability continues to be the dominant rule, strict liability has become the key liability rule in the context of hazardous substances. Whereas absolute liability, even though the Supreme Court enunciated or Supreme Court introduced this principle in 1986, there are very few circumstances in which this principle has been applied in a real life situation. So the actual rule is, while fault based liability continues to be the rule in the ordinary circumstances, as far as hazardous industries or hazardous exceptional circumstances are concerned, the strict liability remains the rule in the context of liability. Now let us look at how this idea of liability has been incorporated in environmental laws in India. First, let us start with this absolute liability. It is very difficult to find the explicit recognition of absolute liability in environmental laws in India. However, the judiciary has applied, or judiciary has not been reluctant in applying the principle of absolute liability in a few circumstances, although it is not in many circumstances that the judiciary has applied it. For example, one of the latest example is in the Sterlite case decided by the Supreme Court in 2013, while asking the sterilized industries to pay 100 crore compensation, the court referred back to the 1986 decision in the Oleum gas leak case. So apparently, this is one of the few cases where absolute liability has been referred and mentioned and apparently used by the judiciary. And the second principle, strict liability, that continues to be the major statutory expression in the context of hazardous industries and industrial accidents, because there are several statutes that endorses strict liability as the applicable principle in the case of industrial accidents and hazardous industries. So what we can see, or what we can conclude from this examination is, legislative intention is apparently goes with fault based liability as a general rule in the case of so called ordinary circumstances, whereas strict liability is the dominant rule as far as industrial accidents and hazardous substances are concerned. So just to cite two examples where this principle of liability has been incorporated in the environmental laws in India is Public Liability Insurance Act 1991. And this statute explicitly endorses no fault liability, which could be taken as endorsement of the strict liability principle in the case of industrial accident. It is pertinent to note that this Public Liability Insurance Act 1991 is a statutory framework to provide compensation in the case of industrial accident. And the statute explicitly says that the claimant need not prove any wrongful act, neglect or default of any person. That means the claimant just need to provide or establish that the victims have suffered injuries, and they need not explain or need not establish that the other party has committed some error, or the other party has violated any environmental law provisions, or the other party has been in breach of their legal duty. Another example is perhaps the recent example is the National Green Tribunal Act 2010, and in the case of even in this statute, which explicitly endorses this no fault liability in case of accidents. So while this is the expression in the environmental laws in general, or the environmental statutes, so we also need to understand what is the scope of liability in this context. What is the scope of liability in the context of industrial accidents? So, first the pertinent question in this regard is liability for what? So, what the answer we get from environmental statutes, whether it is Public Liability Insurance Act or the National Green Tribunal Act, what we get is that liability in the scope of liability is, or the liability is applicable in the context of death or injury to people, damage to property and damage to environment. While there is a small difference as far as Public Liability Insurance Act is concerned. For example, in the Public Liability Insurance Act 1991, the environment is missing. That means the statute has not included environment within the scope of liability. It only mentions death or injury to any person or damage to property. Whereas the National Green Tribunal Act 2010 is comprehensive in this respect, that it includes both death or injury to any person, damage to property as well as damage to environment. In this context, what we can see is like this is more comprehensive in terms of bringing, or more comprehensive in terms of the scope of the liability. Now, let's try to understand the major schemes envisaged or designed under the Public Liability Insurance Act 1991. As I have already mentioned, the Public Liability Insurance Act 1991, the object of the act was to provide immediate relief in the case of industrial accidents. And that means the idea behind the Public Liability Insurance Act was not to exclude the victims from approaching any other court or any other forum under any other law. And the idea was not to exclude remedies available to victims under any other law. But instead, the idea was to provide immediate relief, probably not to let victims to wait for long to get immediate reliefs. In this case, I mean a major innovative idea introduced by the Public Liability Insurance Act 1991 is to make insurance coverage mandatory for hazardous industries. That means all hazardous industries were supposed to take insurance coverage, and the power to decide the liability issue was vested with the district collector. And in this case, it is very interesting to note that this was not the collector was not acting as a court in this case. The collector has a proactive role to play as far as determination of liability and determination of compensation is concerned. The collector was supposed to hear the claims, and the collector is expected to conduct an inquiry into the claims in this context. So that means whenever an industrial accident occurs, the collector is expected to invite claims from the victims, and the moment the victims submit their claims, the collector is expected to conduct inquiry from his own side. So this means the burden on the victims is much less when compared to a contentious case before a court of law. And here, I mean, this is understandable because when the victims, when they have already suffered injuries and damages, so it's a positive contribution from the part of the law that, I mean, the existing institutional mechanism, say in this case the collector is taking proactive initiatives in terms of fixing liability and compensation. And in this case, whatever the award decided by the collector, and the money has to be paid from the insurance amount. That means the insurer, it is the duty of the insurer to pay the amount. And whenever, I mean, there is a, I mean, if the award is beyond the insured amount prescribed under the Public Liability Insurance Act, the rest of the amount has to come from a fund called Environment Relief Fund, which is supposed to be established by the central government. So there is, and what we can see is that there is a two-tier mechanism prescribed under this statute, that, I mean, the first set of compensation is expected to come from the insurer, and if that is not adequate in terms of covering the compensation, or that is not adequate in terms of compensation, the rest of the amount is supposed to come from the Environment Relief Fund, to be established by the central government under this law. The next major statute in the context is the National Green Tribunal Act, adopted in 2010. It is pertinent to note in this context that, I mean, there were two other statutes adopted in 1995, that is National Environment Tribunal Act and the National Environment Appellate Authority Act 1997. and this National Green Tribunal Act 2010 replaces both these laws. Out of these two, the National Environment Tribunal Act 1995 never came into existence. So I mean, what we can see is the National Green Tribunal Act 2010 is the result of a long-term process after doing a lot of trial and error in this context. Now let's try to understand what has been provided under the National Green Tribunal Act. First, the exclusive it provides exclusive jurisdiction to the National Green Tribunal as far as these environmental matters are concerned. That means no other court can take cognizance of a case concerning environmental issues, and this is both in terms of its original jurisdiction as well as its appellate jurisdiction. And the only appeal that is possible from the decision of the National Green Tribunal is that appeal is permitted to the Supreme Court. And as far as liability is concerned, the applicable principle is that the statute says that the National Green Tribunal will apply no fault liability principle. It also says that the tribunal will apply the polluter pays principle. So, but beyond that, the National Green Tribunal does not provide any guidance as to whether there is any exceptions or what are the kind of criteria to be followed by the tribunal in terms of fixing the amount of compensation. And as far as while it is clear that the compensation in case of damaged or death of people, or damaged or injury to individuals, or damage to property, while it is clear that the compensation will go to concerned individual or group of individuals, whereas damage to environment is concerned, the National Green Tribunal Act provides that the money or the compensation in that context should go to the Environment Relief Fund, and the money is expected to be used for the overall improvement or protection of the environment. While these are the two major important things, it's also useful to look at Bhopal as a case study. This is perhaps one of the worst industrial accidents in India, perhaps one of the worst industrial accidents in the world, and then it may be useful to see how these issues on liability worked in the case of Bhopal litigation. Bhopal gas leak disaster happened in 1984, and the magnitude of this disaster was such that it affected so many thousands of individuals and it continues to affect people, it continues to affect environment. As far as from a legal point of view, the litigation was started immediately after the incident, and there are two important developments that needs to be remembered in the context of Bhopal litigation is the concept of parens patriae. That the central government adopted a legislation in 1985 called Bhopal Gas Leak Disaster Processing of Claims Act 1985. The purpose of this legislation was to apply the principle of parens patriae. Parens patriae means this is a principle that endorses or that allows someone else to proceed or someone else to take care of the litigation on someone else's behalf, or in this case the central government took that responsibility to represent all Bhopal victims. So this is the place where through a legislation court applied this principle of parens patriae in Bhopal in Bhopal litigation. The purpose was to speed up the litigation process. Another major legal issue pertinent in the Bhopal litigation context is the forum non-convenience, because it's pertinent to remember that first the case was fought in the United States, where the headquarters of the Union Carbide was situated, and the case was rejected by the US court by citing this concept called forum non-convenience. This meant the court found the United States as an improper forum to decide the case, and to put it in a different way, the US court found the Indian judiciary or the forum in India as the appropriate forum to fight the case, and this is the context in which the litigation came back to India. And as far as the landmarks in terms of Bhopal litigation orders are concerned, on 17th December 1984 there was his first interim order granting rupees 350 crores as the compensation by the District Court Bhopal, and this was subsequently, the interim relief was subsequently reduced to 250 crores by the High Court. And later on, when the issue reached before the Supreme Court in 1989, somehow under the auspices of the Supreme Court, the matter reached to a settlement. The matter was settled for $470 million US. And it's very interesting to note that the legal consequence of the settlement was, after the settlement, the Union Carbide and all its subsidiaries were absolved from all civil and criminal liability. It's very important to note that even the Union Carbide was, through this settlement, through the civil proceedings, the Union Carbide was absolved from criminal liability as well. And this obviously triggered a controversy questioning the propriety of the settlement that absolving the Union Carbide from all criminal liabilities also. And again, in the case of settlement, this was not a settlement after determining the liability of the company. But later on, apparently due to the controversy and challenge on the propriety as far as the criminal liability is concerned, in 1991 criminal cases were revived. However, in 1996, the Supreme Court diluted the charges against the Union Carbide and its officials, and the charges were diluted from culpable homicide to rash and negligent act. So overall, the scenario is, even though the matter was settled under the auspices of the Supreme Court, the misery continues. Even there are several reports, including a report from reputed organizations like the Center for Science and Environment. It says that the environment continues to be polluted, and the people continue to suffer, and even we can even witness that the Bhopal victims continue their struggle both at the state level as well as at the central level for justice. So that means what happened, even after 30 years, almost 30 years, people continue to suffer after this Bhopal incident, and this prompted the Supreme Court in 2012 to give direction to the government to address the continued misery, direction to the state government as well as to the central government to take adequate care in terms of removing wastes or sludges from the Bhopal site. So to conclude, what we can see is that even though we have a few statutes, even though we have established principles like whether it is strict liability or absolute liability, or even though we have these principles endorsed in various statutes, we still have some challenges. One is obviously this burden of proof. In order to determine liability, it is very important that the claimant should establish cause-effect relationship. But as I have already mentioned, in the case of environmental disputes, it is very difficult to establish cause-effect relation, especially when the victims are poor and vulnerable. It is very difficult, or it is extremely difficult for them to establish this cause-effect relationship in a manner that is acceptable for a court of law. In this situation, an important question is whether it is proper to shift the burden. That means it is for whether we can think about shifting the burden to the industries, and presumably they have technical expertise and scientific expertise as well as financial resources. So what about a scenario where the claimants just need to make their claims and the burden is upon the industries to prove that it is not their fault. And the second major issue is compensation. The pertinent question is how to fix or how to determine the quantum of compensation. There are a couple of theories in this context. One could be the principle of restitution. The idea is the compensation, the purpose of the compensation is to restate the possession as if nothing happened. And this is apparently more or less a principle which is close to this principle of restitution has been applied by the National Green Tribunal in a case, Ambuja Cements case in 2013, and where the NGT used the term appropriate compensation. In this case, the NGT relied on a calculation made by an expert committee. Apparently, the expert committee might have taken the actual damages cost. So another principle in this context is a deep pocket theory, which was introduced by the Supreme Court when it discussed the absolute liability principle. The idea is the more prosperous is the industries, the more should be the quantum of the amount of compensation. Maybe a purpose of this idea of the idea of deep pocket theory is to create a deterrent effect of compensation on all industries. However, there are very few cases where it has been endorsed but there is one example is the Sterlite Industries case decided by the Supreme Court in 2013, where the court referred back to its 1986 decision and apparently relied on this idea of deep pocket theory and directed the Sterlite Industries to pay 100 crores as compensation. But the last point is, I mean, while victims could represent or victims could argue their cases for damage to individuals as well as to their property, who will take care of the claims from or on behalf of the environment? What we can see from few cases is like, I mean, possibly the court will take or various committees that the court will be appointing to to calculate the amount of compensation would include environment as a category, and some of these environmental statutes also provide explicitly that environment is a category where amount of compensation needs to be calculated against that category also. This is precisely what happened in the case of Ambuja Cements case decided by the National Green Tribunal in 2013, that where the court directed that the amount or the amount of compensation calculated on behalf of environment needs to be deposited in the environment relief fund, and it is for the proper authority to use that amount in the interest of environment. So, while these challenges continues to remain, I mean, what we can also see is that judiciary is trying to address some of these challenges in different ways. Thank you.